Dumelang! Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. There was no video last week due to circumstances beyond my control. However, I did put in a snippet on my Facebook page, Botswana Thinking Law, where I talk about the difference between legal fees and legal costs. So follow my Facebook page to get a few snippets here and there every now and then. In this part 2 of court process, we will be talking about application proceedings. Yes, we will be dealing with the infamous Plascon-Evans rule. Before we get started, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. I also wanted to let you know that the video also has timestamps. And if you're on a laptop or computer, if you're looking at the video, you'll see at the bottom of the video there's a broken line there. And every time you go to a certain portion in the broken line, you'll see that it's a specific topic. So you can use that to skip to different topics on the video. Or if you're also on your computer or laptop or on your phone, you can go to the description. And the way to get to the description when you're on your laptop or computer is to go to show more, scroll down from the socials, you'll see the time codes. If you're on your mobile, you just press the arrow button and it will show you the description. You also scroll down until you get to the time codes, and then you just press on the blue portion on the time codes and it will take you to that particular time and topic on the video. Now back to our video for today. What is an application or motion proceedings process? Applications or motion proceedings are where a person brings a matter to court, and in bringing this matter to court, they have a strong belief that the matter can be resolved on the papers to be filed by the parties only. And the reason I say this is because in application proceedings or motion proceedings, there are no witnesses that are called to come and give oral evidence to the court. Now, where the infamous Plascon-Evans rule comes into play is that a party who brings a matter by way of application or notice of motion is saying to the court, when you look at the papers that are brought before you, and if you look at the papers that the other party will bring if they are opposing my application, you will be able to come to a conclusion and a decision in this matter without having to hear people giving oral evidence. Now, this is an important distinction that has to be looked at in deciding whether or not to bring a matter by writ of summons, as explained in part 1, or by application. And this consideration is whether or not there are disputes of fact which can or cannot be decided on papers alone. If the disputes can be decided on papers alone, then the application is the process to use. If the dispute cannot be decided on papers alone, and the court has to hear people coming to give evidence, then the application process is not the right process to use. Now, having said that, there are certain matters that in terms of the law have to be brought by way of application. Examples of such matters are urgent applications, where the law specifically says if you want to come to court on urgency, you must bring an application. This is the case whether or not there are these disputes of fact that might require oral evidence. And the reason why this is because there are certain rules that have to be met or elements to be met in order for a person to satisfy the court that their matter is urgent. Another example of a matter that can be brought by application is an application for summary judgment. And I deal with applications for summary judgment in my video in part 1 of court proceedings, where I talk about writs of summons and matters started by way of summons. And in that video, I explained that summary judgment applications have to comply with the law in relation to applications. And today we are going to be dealing with the law relating to applications generally, especially in relation to the different papers to be filed and the process to be followed. Now, a person who brings a matter by way of application is called an applicant. And the person who is sued in an application is called a respondent. Where an applicant brings a matter, they have to start it by a document called a notice of motion. In the notice of motion, they outline what it is that they're asking for from the court. I'll give an example with a maintenance application. A person in a maintenance application may ask that the respondent pay, as an example, 100 pula a month as maintenance of the minor child, and they may also ask for costs, and these costs are asked for on the basis that if this person had been paying maintenance all along, I wouldn't have had to drag them to court. Now, these costs, as explained in my write-up on Facebook, are awarded to a person who is successful. This means that if the applicant is successful, they can be awarded costs. If the respondent is successful, they can be awarded costs. However, a person has to ask for costs. If you don't ask for costs, then the court will not give you those costs. These costs can be on a different scale, and please go and follow my Facebook page and read the different scales in relation to costs. The reason why this issue of costs is important is because it also plays a part in the execution process, which I will be talking about in part 3 on court process. And when I talk about execution process, I'm not talking about where people have been sentenced due to a capital offense. In the notice of motion, the applicant has to give the address where they will receive all court process. They have to give the address of the respondent, and they have to outline how much time the respondent has to give what is called a notice of opposition, and how much time the respondent has to give what is called an answering affidavit. Attached to this notice of motion are a few documents that are necessary. One of these documents is called a founding affidavit. A founding affidavit is where the applicant outlines the story or tells the story for why they are asking for what they are from the court. If we carry on the example of the maintenance, the story could be sometime in 2000, myself and the respondent had a child together. The respondent has been looking after this child in the amount of 100 pula per month, and he has been doing that, or she has been doing that for the past 10 years. However, Sometime 6 months ago, the respondent just stopped paying maintenance. And when I ask them why they stopped, they don't give me an explanation. And in that respect, I am asking for an order from this court for maintenance for the minor child. After the person has given their story in the founding affidavit, they then also include a document called a draft order. And in the draft order, they are repeating what is in the notice of motion, which is what it is that they're asking for from the court. Sometimes it is necessary, in addition to the founding affidavit, to file an affidavit called a confirmatory affidavit or a supporting affidavit. The difference between the two affidavits is that in relation to the confirmatory affidavit, the person in the founding affidavit is not the one who the thing happened to. I'll give an example. If a person wants to bring an urgent application for an interdict, which is to stop someone from doing something, so they want to interdict a person from coming into their yard. And at the time the person keeps coming into the yard, they're not at home. It is maybe an adult who was at home that kept seeing someone come into the yard. The person that brings the application is the owner of the yard or the person who is leasing the property, because they are the one that has a right to protect. But because they were not there when all of this entry into the yard happened, they can only say, the person who was there told me that this person keeps coming into my yard. And the confirmatory affidavit will be of the person who saw this individual come into the yard. And they will say, I confirm what is said in the founding affidavit, that this person or individual has come into the yard. He came or she came into the yard on this day, and this is what happened. And the reason why this is important is because the individual who is at home, because they don't have a right to protect, they are not the ones that can do the founding affidavit. But because they are the ones who have direct knowledge, they have to do the confirmatory affidavit. The supporting affidavit, however, is different. The supporting affidavit is meant to support what is said in the founding affidavit. When we carry on the example of the individual who has been entering the yard, is where the person who is renting the yard or who is the owner was there with someone else when the individual came into the house or into the yard multiple times. And in their founding affidavit, they will say, this individual has come into my yard, I've asked them to stop and they are refusing. And when this person came into my yard, I was with person X. This person X in their supporting affidavit will confirm that they were there and this is what happened. And in that way, they are giving support to what is said in the founding affidavit. Now, the notice of motion, as previously said, will give timelines for filing of the notice of opposition and answering affidavit by the respondent. The timeline for the notice of opposition is 5 days. And when I say 5 days, I mean court days, meaning it doesn't include weekends and public holidays. And the timelines for filing of an answering affidavit are 14 court days, meaning you don't count weekends and public holidays. The application is filed at court. If the person is is using an attorney, one important document that has to be there is a power of attorney. If the applicant is a juristic person, being a company or such other entities, then there must be a resolution. Watch my videos where I deal with legal capacity, because I also deal with different entities in there. There must be an accompanying resolution, whether or not there's an attorney appointed. If there's an attorney appointed, the difference is that then there has to be something called a power of attorney. Once the application is issued by the court, it will have the case number, the judge, and the court that the matter is being handled in. An example is it can give the case number, and the matter might be heard before a judge in Lobatse, even if it is filed in the court in Gaborone. Once the application is issued, then the application has to be served on the respondent. However, I must make a distinction here to say there are certain instances where the law allows for an application to not yet be served on the respondent. And that is in instances where the applicant says, "Give me the order that I'm asking for before I serve. Because if I serve first, then the respondent will run away." And so the order is meant to maintain the situation until the full matter is heard. And these are called interim orders. An example of this is what is called a landlord's hypothec. And here I will be touching briefly on this, but I will deal with landlord and tenant law as time goes by in this channel. A landlord's hypothec is where a landlord says, "I want to attach the property belonging to the tenant, which property is in my house, for example, because they owe me rent for quite some time. If I give them the application without the order, then tomorrow they would have run off. They would have cleared out the house and run off, and therefore it will be more difficult for me to recover my rent." This is simply a way of it, an example where you are asking for the order first before you serve. However, in this video, we are dealing with the general process where you are serving before you get your order. Once you have served the respondent with the application, then the respondent has 5 days, as explained, to give their notice of opposition. And the notice of opposition is simply a standard document where they say they intend to oppose the matter. Then they have to serve this notice of opposition within the same 5 court days on the applicant. After that, they have to also file the answering affidavit within 14 court days of receiving the application, not of filing the notice of opposition. In the answering affidavit, the respondent actually responds or answers the allegations in the founding affidavit. They respond paragraph by paragraph and also give their story. When we carry on that example of the maintenance, the respondent could say, "No, I have been paying maintenance. However, when the child became a major, I started paying maintenance directly to the child." Then they produce whatever proof that they are able to produce to show that yes, they have been maintaining this child directly. And I will be dealing with this issue of majority and support and so on in videos to come on this channel when I deal with the law relating to children. In the answering affidavit, the respondent also has to set out what they are asking for from the court, and in most instances is for the matter to be dismissed and for them to be awarded costs. The reason I say in most instances is because sometimes the respondent can bring what is called a counter application. And in the counter application, the respondent is saying, you have sued me for maintenance of the minor child, but now I am suing you for something else. I'll give an example. If the parties have 2 children and the applicant is suing in respect of the first child, who is now a major, and the respondent has answered that allegation, and the younger child, who is not yet a major, is living with the respondent, and the applicant has not been maintaining that child, then the respondent can bring in a counter application to say, you have to pay me maintenance in the amount of 50 pula a month for this child that I'm living with. And in that counter application, they follow the same rules as the founding affidavit in the initial application brought by the applicant. They have to have their own founding affidavit. They have to also have their own draft order in respect of the counter application. The counter application has to be filed and served within the 14 court days allowed for the answering affidavit, and it has to be filed together with the answering affidavit. Now, if there's a counter application, then it follows the same rules as a simple, straightforward application. Now, once the answering affidavit has been filed, and in the notice of opposition, the respondent has set out the address where they are to receive all court process, and these documents have been served on the applicant on time, then the applicant will file within 7 court days a replying affidavit. And this replying affidavit would be to respond to what is in the answering affidavit, especially if what is in the answering affidavit was not covered by what was said in the founding affidavit. So carrying on this example of the maintenance, the applicant can say, you have not actually been paying this maintenance to this child, as evidenced by this conversation I had with this child, and because this child is now a major, they are also able to file or sign a confirmatory affidavit. Where there is a counter application, then the applicant has to file an answering affidavit along the same lines as the answering affidavit filed by the respondent in the main application. And in it, they answer the allegations in the founding affidavit to the counter application. This has to be filed and served within 14 court days. So replying affidavit has to be within 7 court days and answering affidavit within 14 court days. After the last replying affidavit, if there's a counter application or after the replying affidavit, there are instances where the matter might have been called for the first time before the court during or in between these papers, or the matter might be called for the first time after the closing of pleadings. And closing of pleadings is where the replying affidavit has been filed. And in that instance, the matter is called for what is called roll call. And I explain in part 1 of court process discussion what a roll call is. At roll call, the people will tell the judge the status of the matter, meaning what pleadings they have filed. If they are still to file more pleadings, then they agree on when they will file and when they can come back to court. If the replying affidavit has already been filed, then the parties will ask for a date for argument from the court. And this date for argument will be where now they are supposed to use the law to demonstrate to the court why they are entitled to what they are asking for. Before a matter can be heard for argument, the parties will have to file what is called heads of argument. And heads of argument are where the person sets out the law that supports their decision in writing. And then the argument is merely to add on to what has already been put in the heads of argument. Now, heads of argument usually can be filed at least 4 court days before argument, but sometimes the judge might ask that heads of argument be filed long before then. In addition to that, sometimes if the heads of argument are comprehensive enough, the judge might decide to look only at the heads of argument and make a decision without hearing oral argument. And that is why it is important for heads of argument to be comprehensive and deal with the matter in full. Whether the court decides to hear oral argument or simply decide on written heads of argument, once the decision is given by the court, then that decision has to be implemented. And implementation of the decision could be through various ways. Sometimes when the order or decision comes out, and this example of maintenance carrying on, then the person who the judgment or order is against may decide to simply pay. Other times it might be necessary to undergo the execution process. And this execution process will be dealt with in part 3 when we're talking about court process. But in addition to the execution process, someone can bring an application called an application for contempt. And the application for contempt follows the same rules in relation to application. And when I say that, I mean in relation to the documents to be filed. And this application is brought where a party is saying there was this order given and this person has not fulfilled or has not complied with that order. Now, applications for contempt or contempt applications are specialized types of applications, meaning that even if there are disputes of fact that might require oral evidence, the law says you bring an application for contempt. And this falls under the same category as urgent applications and so on. Now, I hope you received something of use in this video. Please like, share, subscribe, follow me on Facebook, Twitter, and I hope you will join me on my next video where, like I said, I will be dealing with the execution process. Thank you for joining me. Bye.